Good morning. Please be seated. This is the time and date set for oral argument in cause number CV180641 and CV180642, Starr Surplus Lines Insurance Company versus Starr Roofing and Transwestern Commercial Services. These proceedings are being video and audio recorded and also live streamed now, so we ask counsel to identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal. Also, we've read the briefs, we've conferenced this case, and are familiar with the facts, so use that accordingly. At this point, are we ready, counsel?
Yes,
Please proceed.
Good morning.
Good morning.
Brent Phillips on behalf of Appellant Starr Surplus Lines Insurance Company. As you mentioned, you've already read our briefs, and I'd like to first start out, and rather than re-argue what's already in our briefs, I'd like to address any questions you may have in both appeals. There's two appeals. There's the Transwestern appeal, and there's the Starr Roofing appeal. And before I re-argue what's in my brief, I'd prefer to address any questions or concerns that the court may have.
Why don't you start by telling us, we've got how do we pronounce it?
Keggy case.
We've got the Keggy case. Why don't we start there?
Okay. Rather than beat around the bush in our appeal, we attacked it directly. We believe that Keggy was decided wrong based upon well-established Arizona law. For over 100 years, Arizona Supreme Court has stated that insurance contracts are to be interpreted according to the plain and ordinary language. Technical terms are not to be used. It's to be interpreted based upon the language of a layman.
Well, I'm suspecting that when Keggy filed, or when a petition for review was filed in that case, that the same argument was made to the Supreme Court.
I can't speak to that. I don't know if there was a petition. I can't remember offhand, but nevertheless, the court did not make that, did not follow.
They did not accept review, right?
Yeah, and so I really can't. There have been many reasons why the Supreme Court may have not accepted review. And the interesting thing about Keggy is, I think I'd like to first start out and kind of clarify the issues. There's been some confusion on appellee's side there. The insurance or the pollution exclusion, or the analysis of the pollution exclusion, is basically a two-step analysis. First, does the substance involved qualify as a pollutant under the relevant insurance policy? And the second prong is the application of the pollution exclusion. And I see that being conflated. And what I mean by that, in Keggy, they started out and reviewed the substances involved, a bacterial material, and they concluded, based upon the plain language of the policy, that they did not qualify as pollutants. The Keggy court could have stopped at that point and said, the pollution exclusion doesn't apply because the materials involved do not qualify as pollutants. But it took a step further. It went further and reviewed the application. And that's where, and I don't take issue with how they came to the conclusion or the analysis they used to determine that those materials were not pollutants as defined under the policy. They used the plain language. I may have reached a different conclusion, but the analysis was correct. Where I take issue is on the application of the pollution exclusion. Was there a discharge, seepage, migration, release, escape of a pollutant? Instead, there they moved into an analysis based upon that's used to when there's an ambiguity in an insurance contract. But the problem with their using that analysis, they never determined or provided any analysis that the policy was ambiguous based upon the facts of that case. And instead, they just jumped right into the analysis using a variety of different factors, the transaction as a whole, the drafting history, the reasonable expectations, and that's where I take it. There was no basis for them to go that route. They should have just stuck to the plain language. And
so Mr. Phillips, I do have a kind of a question.
Sure.
Because Keggy was decided some years ago. there's been a lot of litigation over this type of clause. What I'm curious about, is there anything in the record that explains to us why, in all those intervening years, the language of this exclusion has not changed in any material way?
That, Your Honor, okay, so I'll step back a little bit and just get into the drafting. The original pollution exclusion was called the qualified pollution exclusion because it had a sudden and accidental exception. Then it went to the absolute pollution exclusion, which is exclusion F within in the coverage form. And that is the exclusion that was at issue in KEGI, the absolute pollution. But the language has changed. Now they've gone to the total pollution exclusion, which is the one that is attached to the Starr policy. So it has changed substantially. And one of the interesting facts that has changed, even in relation to the absolute pollution exclusion, is, as we point out, that the absolute pollution exclusion and exclusion F within the Starr policy form and all other ISO policy forms has two exceptions. Two exceptions that would have provided coverage for the exact type of pollution occurrence involved in the underlying action. And that's how we can't get past. There can be no reasonable expectation of coverage. What had the insured, or Mr. Yoder, who was the risk manager for Starr Roofing, who has 35 years of insurance experience, risk management experience, a very sophisticated consumer of insurance. He was a claims adjuster, a broker, an underwriter. So he acknowledged that he had read the policy, recognized that the total pollution exclusion modified the coverage under the policy, but yet still went ahead and bound coverage. So to answer your question directly, the terms of the pollution exclusion have changed substantially since 1970, and then again in 86, and then with the total pollution exclusion attached to the Starr policy in 98.
We talk about him being a sophisticated consumer of insurance, that he has a lot of experience, etc. Wouldn't part of his experience and knowledge include understanding what KEGI says and that it is the applicable law in Arizona?
I can't speak to his understanding of KEGI. He may have, but on the other hand, he also recognized that they had pollution exposure. They had 3 pollution policies through American Safety. Their argument is these were required by contract. They didn't believe they needed them based upon KEGI, but nevertheless, somebody believed that they needed them. Those were the people that they contracted with. They believed that there was pollution exposure, and they required them to have them per contract. And part of the arguments being made by appellees is there's this doomsday scenario that were the court to modify or overrule or limit KEGI, that there would be a huge swath of claims that wouldn't be covered. That's absolutely false. There are pollution liability policies which Starr Roofing purchased. There's no argument that pollution liability policies aren't readily available. In fact, the pollution liability policies purchased by Starr Roofing covered this pollution occurrence. So getting back, the point is the pollution exclusion has changed substantially over the years. And the pollution exclusion attached to the Starr policy unambiguously excludes coverage for the claims in the underlying action. The appellees don't even argue that the plain language of the pollution exclusion precludes coverage. There's not a word in their brief that says it wouldn't. And again, the second point is they don't argue that for over 100 years, the Arizona Supreme Court has applied the plain language analysis when interpreting an insurance contract.
What's your best case for that example? Give me an example where plain language has been applied to an exclusion and the court stopped there, just said plain language.
Well, there's a number we've cited in our brief here. There's the, in fact, it is the, fact, it's the Arizona Supreme Court, the case of, I want to make sure that I give you the complete name here. Preferred risk mutual insurance versus Llewellyn. In fact, the court admonished, stated that before moving into the analysis used for when there's to determine whether there's an let me step back. The Supreme Court in preferred risk, they stated there must be an actual ambiguity in the insurance contract before you can apply the analysis for an ambiguous contract. And they stopped at the plain language. They wanted to state this is the, use the plain language if they're unless based upon the facts of that case that that you need to employ a plain the ambiguous analysis. And when there's ambiguity, it means it's susceptible to two interpretations.
Too reasonable.
Too reasonable.
More than one reasonable.
More than, yeah, exactly. I'm sorry, you're correct. And with the total pollution exclusion attached to the Starr policy, it's very clear. I mean, it's very simple. There's no.
Very clear as to the breadth of those terms, like thermal irritant or contaminant.
The
It's very
definition
clear
of
the
it.
scope. Are those terms defined?
Thermal irritant?
Yeah, or fumes or contaminant or smoke or vapor, are those defined terms?
They're not defined in the policy, but smoke is a very the average layman would know what smoke is. The average layman would know what fumes is. The average layman would know what vapors are. It's not something that I would think you would need to define within the policy, because policies, if you defined every term in a policy, the policy would end up being about 1,000 pages long. Then you need a definition for the definitions. So it's you're using plain, ordinary language understood by a layman. The layman would understand that and it gets also back with the breadth. It's based upon the facts of this case. And the facts of this case show that the materials used by Starr Roofing do qualify as pollutants. They're classified as hazardous substances under numerous environmental statutes. The material data sheets attached, they come with it, or required to come with it, list a laundry list of the hazards associated with burning of the eyes, the mucous membranes, that they recommend using a respirator when levels are above a certain concentration. So, I mean, again, it gets back to the facts of this case. We can talk about a lot of different things, but the facts of this case show that those items used by Starr Roofing to perform its roofing operations qualify as pollutants. And there's absolutely zero evidence to rebut that. We submitted the declaration or testimony of Dr. Nadia Moore, a PhD in environmental and human toxicology. And it was unrebutted with that testimony. And when there's unrebutted expert testimony, the court has to accept that on a summary judgment because it's established as a fact. There was no qualified testimony to rebut Dr. Moore's testimony. Well, we'll move on to the, I don't know if you have any questions, I'm looking at my time here, on the Transwestern, if you want to, I wanted to make sure we were able to hit that as well.
Yeah, please proceed.
Okay. Well, the Transwestern appeal, I think, is probably the most simple. We can go around and around all day. There was a material, there was the Transwestern moved for summary judgment on the issue of waiver, estoppel, and laches. To show estoppel, you must show an unreasonable delay in the communication of a reservation of rights. And the second prong is prejudice due to that delay. In this case, there were material issues of fact. There were facts that would create a material issue of fact that should have gone to trial, whether there was a delay. But the one issue that they can't get past is there's no prejudice. It's law school 101. When you have no damages, you have no prejudice. And it's well-established insurance law that when another insurer is fully defending and indemnifying you, you have no damages or prejudice. And in this case, Transwestern was being fully defended and indemnified by Zurich. That's just, uh, that's just basic insurance law. I don't quite understand how the Superior Court didn't understand that, but nevertheless, they did grant the summary judgment. And there can be no prejudice. Transwestern never explains how they suffered prejudice when they're being fully indemnified and defended by Zurich. They put out a lot of different claims of prejudice. Those, as we pointed out in our brief, are just merely red herrings. I mean, the Bellinger was conflicted. They didn't pursue Bellinger's. Even Bellinger was conflicted. They didn't pursue coverage under the pollution policies for American safety. They had indemnity claims that they could have pursued. As we point out, even assuming that those were correct, we proved that they suffered no prejudice because of those, because they never showed that there was coverage under the American safety policy or an insured. If they weren't an insured and there was no coverage, they couldn't have suffered prejudice due to that. The indemnity claims they may have had against different parties, we showed that they still could have pursued those. They never discussed how the Bellinger's conflict prejudiced their defense. But getting back, the alpha and the omega of this discussion, and it ends right there, is there's absolutely no way they can suffer prejudice when they've been fully defended and indemnified by Zurich. The only body suffering prejudice is Zurich. And ironically enough, we point to the Zurich case out of the Arizona District Court, that Zurich made the same argument when they were sued. And so Zurich may have suffered prejudice, but that is not prejudice to the insured. Under Arizona law, the prejudice must be to the insured and not to the insurer. I know some of them I've got 3 minutes and 45 seconds left. I'd like to reserve that for any rebuttal.
Thank you.
Thank you.
Good morning. My name is Jay Grafe, and with co-counsel Michael Cordier, we represent Starr Roofing. It was almost 19 years ago when a panel of judges in this exact division decided that when applying a pollution exclusion, the law in Arizona shall be applied, and they shall apply the narrower interpretation of that endorsement and restrict preclusion of a claim under a pollution exclusion to only traditional environmental pollutants or a traditional environmental pollution event.
It was great. Mr. Phillips tells us the language of the exclusion has changed substantially. What's your take on that?
There are words that have changed, but when it breaks down to the crux of the endorsements, they are still the same. They define pollutant very loosely, as Judge Brown indicated. If you look at the definition of a pollutant in the Starr policy, it basically relates to an irritating odor, irritating smoke. And it is that language that the Keggy court looked at and said it creates susceptible to multiple interpretations. And as a result of those terms, irritant, contaminant, and so forth, because of their loose, open interpretation and susceptibility to multiple interpretations, that's why the Keggy court applied the three-pronged test that they did. So the Keggy court didn't have to look at the plain and ordinary language of the endorsement. They were actually required to apply this three-pronged test because they determined the terms to be susceptible to multiple interpretations.
Did they assume without deciding that they were capable of multiple interpretations?
What's that?
Didn't they assume without deciding? I'm reading paragraph 20 of the decision. It says, assuming without deciding that the clause could reasonably interpret it this way, and that would render the clause ambiguous. Did they ever come out and say specifically exactly that there was a definitive statement in Keggy that the pollution exclusion was ambiguous.
Well, they did talk about the history of cases
Understood.
and the susceptibility of eviscerating coverage if they allowed the exact
Sure,
interpretation.
but that's classic, that's like statutory interpretation, jumping to to the background and history of the legislation, whatever. You don't get there
Right.
unless it's ambiguous on its face. Let's back up a little bit.
Okay.
In KEGI, the first issue in KEGI, obviously, as counsel explained, was the definition of pollutants.
Mhm.
And the court said, thus, the exclusion does not apply to preclude coverage for KEGI's industries because they said that was under the plain language.
And that related
That
related the bacterial issue with the
right,
fecal
but
matter, correct?
The exclusion precluded coverage. Why not stop? Why didn't our court stop right there?
Well,
And could have our court stopped right there?
Northbrook went on to argue
I
that
understand there's disarguments, but couldn't our court have stopped right there with that conclusion? And is arguably, does that weaken the rest of the analysis?
no, I don't think so, because it says the exclusion does not apply to preclude coverage when we're talking about the bacterial pollutants, because it's not included within the term of pollutants. So the endorsement does not apply. Therefore, Northbrook did not prevail on that argument. That's why Northbrook then took it to the next state argument and said it's a contaminant and we're not focusing on the bacterial aspect. And it was at that point where the court said, because of this expansive definition of contaminant or irritant, as they later reference, and the susceptibility to the multiple interpretations of those terms, that's when they applied the three-prong test. And that's when they proceeded with the public policy, the reasonable expectation, or the purpose of the endorsement and the transaction as a whole. And we can get into those three prongs if you'd like, but they're well briefed, and I do want to save some time for my colleague who wants to address his appeal for the Transwestern. So if you have any issues on the three-prong test, we can discuss that. But the KEGI case was well reasoned, based on applicable Arizona law. There has been no changes in the insurance industry. There's been no changes in the Arizona law to change the basis for that decision. Judge Winthrop, you mentioned bringing it up to the Court of Appeals or the Supreme Court. The Supreme Court denied review because there was no basis, because the analysis that KEGI performed was correct. It's not plain and ordinary meaning. It is the three-prong test, and the court properly applied that three-prong test to come to the determination that these pollution exclusions only apply to traditional environmental pollutants and traditional environmental pollution events. Judge Mahoney took that same analysis and determined that this roofing product does not constitute a traditional pollution or traditional environmental pollutant, and there was no traditional environmental pollution event which caused the release of these so-called toxic odors, which we've all seen were not determined to be toxic by the air quality tests that were performed at the time of the subject incident. So KEGI was accurate. Judge Mahoney applied KEGI correctly and actually looked to two cases that the Arizona District Court held in the Saba versus Occidental and National Union versus James River cases that interpreted KEGI and further expanded a little bit on KEGI. Didn't change, didn't modify, but explained it a little bit further. And Judge Mahoney relied on the reasoning and explanation in both of those cases to support her ultimate ruling, finding that the pollution exclusion in this case did not apply, and Starr Surplus had a duty to defend and indemnify Starr Roofing. I'm going to defer to my partner at this point unless anyone has any specific questions relating to the appeal for Starr Roofing. Okay. Thank you.
Thank you, counsel.
Good morning, Your Honors.
Good
I'm
morning.
Michael Silliman, and I represent Transwestern Commercial Services, Arizona LLC. And we are here on Judge Blomo's dismissal of the complaint against Transwestern on the grounds of waiver, estoppel, and laches, and the award of attorney's fees and costs by Judge Mahoney. The appellant claims that Transwestern failed to show prejudice. But prejudice was found by the court, and we've outlined it in our brief, and I won't go into detail. But I would point out to you that Starr Surplus went to the extreme of appointing a counsel for Transwestern who had a clear conflict of interest in his dual representation of Starr Roofing and Transwestern. He, in fact, stated in a letter to Transwestern that there is a clear disparity between the interests of Transwestern and Starr Roofing. And in defending Starr Roofing, he stated that he would have had to show negligence on the part of Transwestern's part in order to deny Starr Roofing's duty to defend and indemnify, while at the same time, he would have had to show no negligence by Transwestern in order to impose a duty to defend and indemnify Transwestern by Starr Roofing. In addition, Starr tried to cover up its tardy reservation of rights through a sham declaration, which was found to be sham by the court in minute entry that it issued on January 12, 2017. If I can go on to their attorney's fees and costs.
Could you just
Sure.
take a minute, Mr. Silliman?
Absolutely,
I know
Your
you
Honor.
said it's in the briefs, but explain to us exactly what the prejudice was caused by the delay.
The prejudice.
Alleged delay.
Sure, absolutely, Your Honor. The prejudice was, one, Transwestern was delayed in contacting other carriers that it could have. It basically did not. Once it determined that there was no reservation of rights, there was no need to seek coverage from other carriers.
Well, Mr. Phillips tells us that Transwestern isn't prejudiced at all because Zurich was there to fully indemnify you for any losses.
Yes, Your Honor, and this court, in fact, has found in the Catalina Foothills case that an insurer who fails to issue a timely reservation of rights can't escape liability for prejudice because a party protects itself with multiple policies, or when another insurer defends in order to make a liable insurer pay. So the mere fact that Zurich was covering it while it was attempting to get coverage by Starr Surplus does not defeat an application for or an award of attorney's fees under Arizona case law. In addition, Starr says that there's no eligibility for attorney's fees under 12-341, or costs, I mean, or fees under 12-341.01. But those statutes specifically say that costs are mandatory for costs, are mandatory to a successful party, and for fees, they do not limit an award of fees only to successful parties who have paid their own fees. There is no limitation in that regard. In fact, there's no requirement that the fees must have been incurred or expended by the prevailing party under 12-341.01. There's also an issue of whether there was a late application for attorney's fees, but as Judge Mahoney determined in a minute entry in awarding the attorney's fees, there was some confusion from Judge Blomo's earlier order putting on hold an earlier application for attorney's fees, which was timely filed. We argue that this application should be determined under Rule 54G3A1. They argue it should be viewed under A2. Even under A1, we were 2 days late, without a doubt. But we had already filed an application for attorney's fees timely, much earlier. So even if you discount the application that we filed later, we still have an application for attorney's fees that is timely and that could result in an award of fees. The voluntary payments doctrine, which is argued by counsel, is not applicable. That doctrine involves attempts by a party to recover fees that that party voluntarily paid to another without an obligation to do so. Transwestern is not seeking monies it paid to Starr, and Zurich is not a party in this case. So the voluntary payments doctrine is simply not applicable. Likewise, the collateral source rule is analogous, but it is not applicable in this case. The appellant contends that because Transwestern was represented and fully defended by Zurich, it suffered no prejudice, no injury, and therefore the collateral source rule is not applicable. But it's not applicable in any event because attorney's fees are not damages. And 12341.01 clearly allows for an award of attorney's fees to the successful party. They cite no case that says Zurich was required to have a legal obligation to pay its own attorney's fees or costs in order to recover attorney's fees or costs as a prevailing party. If you have any questions, I'd be glad to answer them. All right.
Good.
Thank you.
Thank you. You're wanting to use the remaining 5?
I don't think I'll need the full 5, but
Okay.
Your Honor, I would like to address the attorney's fees issue that was been brought in our claim. Starr Surplus has challenged Judge Mahoney's analysis of our attorney's fees claim, and the basis is that Starr Surplus does not believe that Judge Mahoney conducted a reasonableness analysis of the attorney's fees. But Judge Mahoney's order specifically says that Starr Surplus was entitled to recover reasonable attorney's fees under 12341.01, and her holding specifically says that after consideration of all of the factors in the Warner case, that Starr Roofing was entitled to its reasonable attorney's fees in the amount of, and she sets forth the amount. So based on the language of Judge Mahoney's own order, it is clear that she did take into consideration the reasonableness as well as the various Warner factors, and concluded that Starr Roofing was entitled to the attorney's fees in the amount that she awarded, and those attorney's fees are in fact reasonable. So it's clear that she did conduct a reasonableness analysis. And just wondering if there's any issues that came back up on the Starr Roofing appeal relating to the Keggy case or anything related to that other issues.
Just one thing,
Yep.
I don't know if you covered this, I apologize for you, but I think there's assertions made several in the appellant's briefing that this is truly the minority rule. Keggy represents a minority rule throughout the United States. Is that correct in your opinion? Is that a fair statement? Or tell me what your thoughts on that.
Sure.
Is that not a fair statement?
Sure. I think when the Keggy ruling was issued in 2000, it might have been the minority rule. And Starr Surplus cites to couch on insurance a particular section that says that it is that the broad interpretation is actually the majority rule. However, the cases that are cited in that particular provision in that treatise identifies cases back from the late 90s, early 2000s. So they're very outdated cases. In two scenarios, one by the Arizona District Court in the Saba case in 2014, the Arizona District Court said that the interpretation utilized by Keggy is in the majority of jurisdictions now. Also, the Minnesota Supreme Court, in the case that we cited, did the same analysis in 2016 and determined that the Kegi analysis and the narrower interpretation is utilized by a majority of the jurisdictions. So we see a trend from the late 90s, early 2000, where this narrow interpretation applying the pollution exclusion only to traditional environmental pollution events might have been the minority in the late 90s, early 2000s, but is gaining notoriety and acceptance across jurisdictions such that now it is in the majority. So, so that just further supports the reasoning in Kegi and what the court did, because other courts are finding this exact rule or this exact interpretation to be the proper interpretation. Thank you.
Thank you, counsel.
First, I'd like to just revisit Starr Roofing's appeal. Again, there was Starr Roofing wants to conflate the application of the pollution exclusion with the definition, and when he was addressing Judge Brown's question, the Kegi court said, "We conclude that the plain language of the pollution exclusion does not include total fecal chloroform bacteria within the definition of pollutants. Thus, the exclusion does not apply to preclude coverage for the Kegi injuries." Right there, they applied the plain language analysis, but for some reason began to employ a analysis for when there's an ambiguity on an insurance contract without ever finding the contract to be actually ambiguous based upon those facts. And with regard to couch insurance, that's updated all the time. So, and also the Saba case that he refers to, citing that the majority rule is the narrow interpretation of the that pollution exclusion. That's based upon McKinnon. That's a case that's over 16 years old. That's where the Saba cites. And recently, the Nebraska Supreme Court noted that we cite the case in our reply to amicus curiae brief. The Nebraska Supreme Court states unequivocally that the majority rule is the plain language analysis of the pollution exclusion. Moving to Transwestern's appeal, Mr. Silliman said that the collateral source rule does not apply. One, he's absolutely correct. The collateral source rule does not apply. It's a tort law doctrine, but yet they're trying to use this collateral source rule to claim that Transwestern could not have suffered prejudice. But yet, he just stated that the collateral source rule does not apply. And not one word out of Mr. Silliman's mouth ever disputed that they could not have suffered prejudice due to the fact that Zurich is fully defending and indemnifying. They've never explained how that can happen. In fact, Zurich took that exact same position in the federal district court now, and they want to flip it around. And with regard to recovery of attorney fees under 1234.01, the party must have have paid the attorney fees or have a genuine legal obligation to have paid the fees. They have not. They acknowledge that Transwestern has not paid the fees nor has a genuine legal obligation to pay the fees. Zurich paid all the fees, and the only way an insurance company can collect the fees is if there's coverage under the policy. They dropped the ridiculous argument on appeal that there was coverage under the Zurich policy for the underlying action. As we point out in our brief, that claim would require Starr Surplus to actually have defended Transwestern in its own in Starr Surplus's own lawsuit. There is no coverage under the Zurich policy to recover. The voluntary payments doctrine absolutely precludes coverage when payments are made gratuitously. They were made gratuitously. There was no legal basis for making. There was no coverage under the Zurich policy. It's a CGL policy. It only covers bodily injury and property damage. So they had absolutely no basis for paying. The voluntary payments doctrine precludes coverage. And the Catalina Foothills case, that deals with the recovery of attorney fees, and there was coverage under those policies for those claims. Thank you, Your Honor.
Thank you, counsel. We thank you both for your arguments here this morning. We will take this matter under advisement and issue a written ruling in due course. We are at recess.